My Lords, it is an honour to speak in your Lordship's House for the first time and to do so in support of this bill, introduced by the noble Baroness Williams of Trafford. I'm grateful for the kind words of the noble and learned Lord Garnier and the noble Lords Bach and Davis of Gower. When I succeeded my father in 2002, I never in my dreams expected that I would take my seat. I thought we would no longer be here. But here I am, and after a contested election, if not the sort of election some reformers might endorse. May I begin by saying how welcome everyone here has made me feel. I have received great support from the staff of this House, not least in the library, the digital drop-in, and of course the doorkeepers. I hope this House will forgive me if I say a little about myself. After Oxford, I went to the bar. I practiced under my family name as Guy Mansfield. I was not the first barrister in my family. That was one James Mansfield. In 1772, he, with others, by habeas corpus, secured the liberty of Somerset the slave before the great Lord Mansfield, no relation. James was later Solicitor General and Chief Justice of Common Pleas. His grandson, William, was not a lawyer. He went into the army. He was a distinguished soldier, and he reached the rank of full general. And William Gladstone made him a peer, and he took the title Sandhurst. My great-grandfather practiced a little at the Chancery Bar. My grandfather and father both aspired to be lawyers, but 2 world wars intervened. They both served with distinction and were lucky to survive, but they did not go back to the law afterwards. My early practice covered a wide field, like many in my time: crime, civil and family, and a range of courts. I acted for clients from all backgrounds. I was lucky in my first 2 years to share a room in chambers with the future noble and learned Lord Wolfe. He was a great exemplar. Life was often quite tricky. I wasn't always very good. My wife, not a lawyer, came once to watch me give a plea in mitigation. Ever the kind but critical friend, she said, "Had you nothing better to say?" Some years later, I went off to represent a district council in a planning inquiry. It was my first such. I'd never been to one, never seen one. I was greeted by the planning officer, rather breathlessly, who said, "Oh, Mr. Mansfield, this is my first inquiry. I'm so glad you're here to show me the ropes." Well, I kept my counsel. We survived. We were successful. In 1994, I took silk. I also became a recorder and later a Deputy High Court judge. The 1990s were a time of great change for the bar. The bar had to respond to High Court adversary rights for solicitors, to the introduction of conditional fees. At that time, I chaired in succession 2 bar committees which had to address these. Next, we had the competition inquiry into the legal professions. As a result of that, I chaired the working party which introduced direct access so that people didn't have to go through a solicitor to see a barrister. In 2005, I became chairman of the bar. On my doorstep was the Clementi report. This wanted to introduce widespread change in the regulation of the legal professions. I'm proud that in that year, we on the Bar Council created a new constitution in the space of the year, which took effect from the 1st of January 2006, with a new, separate, independent regulator, the Bar Standards Board, under a lay chair. That was a big achievement, I think. I returned to practice. In 2009, I chaired another working party in response to Sir Rupert Jackson's inquiry into costs in civil cases. This was to look at something called a contingent legal aid fund. We came to the conclusion that government should look at that. That would be a privately funded, not-for-profit scheme to fund civil litigation. Sadly, it went into and remains in the long grass. Not for today, but we must do more to support access to justice in the civil and family courts. In 2012, I took over leading the Foreign Commonwealth Office's legal team, defending claims by 40,000 claimants for damages, Kenyans, for damages for alleged assaults in Kenya during the Mai Mai insurrection. That trial lasted 232 court days. It was far and away the most complex thing I've ever done. When it finished in 2018, I thought, that's it. I retired and I looked for a change of direction. So here I am. I feel greatly privileged to have been elected. I hope my background shows areas where I might be able to contribute, but I will wish to contribute on a wider canvas too. Turning to the bill, and I shall deal with this quite shortly, I have looked at it with the eyes not only of one who sat in the Crown Court as a recorder, but as a member of the public who lives in this great city and travels on public transport like everyone else. I'm conscious the bill has created controversy, and some parts are not necessarily easy. But I suggest its broad principles are correct. Today I shall focus on just 3 of those provisions. First, there are the provisions to protect emergency workers. My daughter is a consultant in the NHS. She works on the wards. She has told me quite a lot of times of incidents of assault, not just in A&E, but actually on the wards. Doctors and nurses deserve protection. Second, I commend the provisions to make different local bodies work together to prevent serious violence. That must be wise. Thirdly, I identify the provisions for the extraction of information from electronic devices. I say nothing about possible improvements by amendment. The principle is sound. I commend this bill to the House. Thank you.